Section 4, that is the definition of, yeah, we have been dealing with the, we have been dealing with the definition of may presume, shall presume, and conclusive proof, because the section 4 itself does not define to you what exactly it means. Now, this section 4 is required to be connected to, it is interconnected with several other sections in the Act, which I have briefly given to you yesterday and also put up today on your group. Then now we will discuss those sections. So these sections mean here the expression may presume mean apart from direct evidence before the court of law, apart from the oral evidence, secondary evidence, circumstantial evidence, which we discuss, the provisions of section 59, 60, 61, 62, 63, 65. Then we also learn that the expression used by the court in proved, not proved, is the matters before it and not evidence before it. Apart from the evidence, the court also considers the various other circumstances which I gave you yesterday: the commissioner's report, the bailiff's report, the demeanor of the witnesses. That all illustrations we gave you yesterday. So today another important chapter, the what we are dealing with is here the inferences which the court would like to draw. These inferences can be drawn by the court when there is no direct evidence, or when there are no eyewitnesses, when there are no documentary evidence. Court presumes certain things must have existed or not existed, must have happened or not happened. So these are called presumptions of law, presumptions of fact. These presumptions of facts and law can be rebuttable and irrebuttable. So yesterday we were dealing with the, the doctrine of may presume, which can best be understood invoking the provisions of section 114, which are known as the presumptions of fact. Presumptions of fact, where you are allowed to lead rebuttable evidence to disprove it. So, whatever presumption the inference the court may draw, the court may draw that you are in possession of a stolen good, you are a thief. That is what the court may presume. So, you can lead evidence to disprove that belief. That inference, your lordship, is not correct. I am not the thief. These goods which I am in my possession belong to my ownership, or they belong to my friend, my family. It is not belonging to the prosecution. The evidence led by the prosecution is incorrect. So let us now come back to section 114. Somewhere midway we remembered it. Yeah. So then I gave you also, apart from the provisions of Indian Evidence Act, there are provisions under the Negotiable Instrument Act. I gave it to you, where presumptions arises here. 118, 119, 120, 121 se lekar 131 of the Negotiable Instrument Act. Now the famous cases of 138 cases, you know, the check bouncing cases, which are known as, under which there is a presumption under section 138. A person who is a holder in due course, means in possession of a bill of exchange or a check, is presumed to be a person entitled to the amount, unless the accused person leads evidence in rebuttal to disprove it. He may take up the plea that there is no enforceable claim in the eyes of law. This check has been stolen from my office, or the complainant had given me this check for the purpose of seeking an illegal favor for him. Maybe he may say that he wanted me to get some order, pay the amount to the minister or some officer to do some contract for him, which I could not get it. The check is bounced. So such checks are not, such amount cannot be enforced. You know that, yeah? Under the Indian Contract Act, section 23 tells you such contracts are opposed to public policy. A and B cannot enter into a contract. I will pay you 1 lakh if you get me a favorable order from a minister. if you get a favorable order from the police officer, or if you get a favorable order from a particular magistrate. This kind of a bribery is not encouraged under the Indian legal system or any legal system. These are called, such contracts are void. They are opposed to public policy. So the accused person can take up the plea that here the amount is the amount, the check which has been given, the bounce is not enforceable amount. So that section 139 will deal with now. Please come back to 114.
Sir, quick question.
Yeah.
Sir, quick question, sir. If you have stolen government property or government property that is not supposed to leave government premises, then mere possession of it is deemed to be a crime, sir?
Possession of a government property? What is the answer question?
Yes, sir. If you have a government property, for example, stamps or seals, then then mere possession of that in private hands outside of government premises is considered to be a crime.
Yeah, you are not supposed to possess them. You have to explain why how you are in possession of it, unless you are an authorized person to keep it with you.
Yes, sir.
You are not supposed to keep it with you. A private person cannot keep in custody a Ashok Chakra and a document relating to the seal of the government or the court. Unauthorized. This amounts to theft under section 379 of the Indian Penal Code. Okay? Now,
thank you.
Yeah, we dealt with the section 114 to understand the meaning of may presume, and we are somewhere in the midway. So, illustration A, we dealt with you are in possession of a stolen good. The court may presume that unless he accuses, that we have explained. Second one also we explain that an accomplice is unworthy of a credit unless he is corroborated in material particular. We discussed this illustration 114b in relation to section 133. 133 said that an accomplice shall be a competent witness against an accused person, and a conviction is not illegal merely. So this again because it is the discretion of a judge to accept the evidence or not. A trial judge, a session judge or a magistrate will balance the evidence, whether you require the uncorroborated testimony, whether you require corroboration. The corroboration provision I mentioned to you yesterday, section 156 and 157. Remember this. Please remember that. Now, when we are dealing with we are covering the entire act. It is while discussing, because one section is connected to other section. Please make a mental note of it. When we speak of corroboration, immediately you must remember section 156 and 157, where the Evidence Act makes it corroboration mean strengthening the evidence already in existence. The evidence, the statements of a person under 161 are not evidence. They require to be corroborated. Mean additional evidence is to be given. Similarly, the statement of a maker under the FIR may be accepted as evidence provided the maker of the FIR stepped into the box. So here the 114b says that here an accomplice means a person who is involved in a joint trial, who is in the commission of the offense along with the other accused, is being tried jointly or maybe separately. His confession or evidence cannot be accepted. The court has to take it with a pinch of salt. It requires corroboration, means the court requires independent evidence. Independent, some other better evidence, some eyewitnesses who have seen it, number one. If there are no eyewitnesses, some documents to connect it. It may be secondary evidence or primary evidence, depending upon what kind of evidence is available. Or the court may be able to draw inference, or maybe circumstantial evidence where the court draws inferences. So unless there is a corroboration to connect, the court is not going to believe the evidence. Okay. Now, the third is we dealt that a bill of exchange accepted and endorsed was accepted and endorsed for good consideration. A bill of exchange means under the Indian Negotiable Act, a check is also a bill of exchange, isn't it? If I am in possession of your check, it is presumed that you have issued the check to me for some consideration. I must have sold you my goods. The court presumes that. Huh? That is the presumption which is arising under, even under the provisions of section, that is chapter 13 of the Negotiable Instrument Act. I am the holder in due course. The holder in due course. Suppose that is how the, unless the person who issued the check, the drawer, takes up the plea that here the check has been stolen. The bill of exchange is not mine. It's fabricated. Otherwise, the court presumes that it's a valid document. Number three, we dealt with here that a thing or a state of thing which has been shown to be in existence within a period of shorter than which such thing, a state of thing, usually cease to exist, is still in existence. So here the court of law will draw inferences as regard the state of thing. A state of thing and existence of thing, what kind of this is directly connected to section 14 of the Evidence Act. Please note that 114D can be read along with the provisions of section 14, where the what kind of evidence is led by the parties and what the court appreciate. Kindly see that here. I will just take you through the section 14. Facts showing the existence of a state of mind or a body or bodily feeling. There are around maximum A to P illustration, which I will go through along with this when we are dealing section 14, is to be taken into consideration. So, certain state of mind, the intention of the parties, feeling, negligence, rashness, goodwill, ill will, a crime committed, something, a fraud committed, concealed act, you cannot come to know. Certain, the court may presume that save and except this man, nobody else has committed. Presumption can be drawn in that regard. In such matters, that is what the provisions say. Now, then 114.
So,
114.
quick question, sir. So, why did they first criminalize bouncing of checks and then decriminalize it?
Because magistrate courts are getting flooded. Huh? Because magistrate is only because that remedy, check bouncing cases, your remedy is adequately dealt under the provisions of Order 39, Rule 1 and 2 CPC. Your money is paid. What is the use of putting a man in jail? Huh? When a person committing adultery not going to jail, why should a person committing a bouncing act should be sent to jail? It's a commercial transaction.
Yes,
Ultimately,
sir.
your interest in recovering your money, for which there is a provision under the provisions of Order 37, Rule 1 and 2 CPC, or file a separate suit, or you can go to the consumer court. Isn't it? There are so many civil remedies. Why send a jail?
Yes, sir.
That is the meaning behind it. Otherwise, they do not want the magistrates court are getting flooded. 138 cases are so many thousands and lakhs are being filed, and there are conflicting judgments. You can see that here. If your check is bounced in Bombay, you can put your check in Ahmedabad, Delhi. You can harass anybody. You know that the on the point of jurisdiction, CRPC is not like CPC. You can only go to a particular court where the court is situated, or where the defendant carries on business. Under the CRPC scheme, know that you can file a criminal complaint in a place where the offense took place, or in a place where the consequences arose. पढ़े ना आपने?
Yes, sir.
हाँ, we are lent in the CRPC के अंदर पढ़ चुके हैं आपने वो. So the CRPC is more liberal in the matter of somebody is calling me. I'll just take it. You all can hear me now? Hello?
Yes, sir. Loud and
Yeah,
clear,
I'm
sir.
sorry. I'm
Yes,
sorry.
sir. Loud and clear.
So, the
No worries,
provisions
sir.
of 138 are being misused. So, you learned under the chapter 12 of the CRPC, some 177 se lekar 189 tak, the jurisdiction of a magistrate, if a check is issued in Bombay, your the other person may be in Delhi, Calcutta, Madras, you can put anywhere and harass you. This harassment doesn't stop, isn't it? That is why, according to me, it is rightly being decriminalized. Ultimately, your purpose is you get the
Thank
money,
you, sir.
double the money. Yes.
Yes, sir.
Yes. Now
So, but
come
you're
back.
able to, you're able to recover the money, sir, with
Yeah,
it no
yeah.
longer being a.
Yeah. Summary suit is more faster. Huh?
Okay,
If
sir.
your check is
Thank you.
bounced under Order 37, Rule 1 and 2 CPC, your remedy is faster. Yeah.
Thank you, sir.
Yeah. Now come to that. Then he says judicial and official acts have been regularly performed. So, see, whatever the magistrate or the judge has passed orders or roznama, the court presumes that they are correctly done, isn't it? It is not open for the parties to challenge the findings of the magistrate or the judge, attributing motives. If the judge has recorded a finding, if you have not filed an appeal against it, and that goes against you. Any finding which is recorded, you must file go in appeal. If you don't file an appeal, and it has the order has reached what finality. So the judicial act has been properly followed and performed. That is the meaning. Then the common course of business has been followed in particular cases. So this common course of business also be discussed, such as that you have dispatched a letter from Mumbai to Delhi by registered AD. The post office has delivered the document to the addressee. In courier, you send it here. So the common course has taken place. The court presumes that here the document which has been sent has been duly delivered. If not delivered, you can take up the plea that it has not been done. Evidence can be led here. Then G में भी देखिए हमने evidence which could be and is not produced would be unfavorable to a person to withhold it. So you are not deliberately producing documents and giving evidence because that will go against you. So the court will draw adverse inferences against you that we discussed it here. Yes. Then H means that if a man refuses to answer a question which he is not compelled to answer by law, the answer if given would be unfavorable to him. So this I gave you an example yesterday. Under the Evidence Act, you are bound to give an answer. Witness cannot excuse himself. He cannot take up shelter under Article 20 subclause 3, which is at the investigation. That is section 132 of the Evidence Act clearly says that the witness has to answer the question, even if it's criminate him. The only protection given to the witness is that he will not be arrested in case of a perjury. Only the provisions of section 340 CRPC can be invoked against him for offences affecting the administration of justice, namely for committing perjury under 193. But it's clear no arrest, though the offence is cognizable. There's a specific mention here, no arrest should be effected. Please note that here. That is this article, that's 114. 114H should be read along with section 132 and also your article 20 subclause 3. Yeah. Then I. When a document creating obligation is in the hand of the obligator, the obligation is discharged. A promissory note, I took a loan from you, executing a promissory note. The original is come back to me after 1 month. The law presumes that I have paid the amount. समझे ना आप? Otherwise, the original remains with you. समझे? A money lender has lent money to Mr. X by execution of a promissory note. Now, promissory note is come back to him, back to the person who borrowed the money. That means the money has been discharged. That is, the court may presume that here nothing is payable. Otherwise, why would the original shouldn't come back to me? In the case of a mortgage document, mortgage property, the title deeds are normally the mortgager deposits with the mortgagee. If the original documents are come back in the possession of the original owner, that is the mortgager, the law presumes that the mortgage amount has been paid, unless contrary evidence can be laid. You understood this? So the court will presume that here, the court will presume that nothing is payable. Yeah. Then देखिए, but the court shall, आई के बाद देखिए, but the court shall have regard to such fact following consideration, whether such maxims or do not apply to a particular before it. Now, as to illustration A, the shopkeeper in his till the mark rupees soon. Yeah, is there in your books? Is it a part of a commentary or a illustration? I think we have completed the 114 illustration A to I, isn't it?
So the act has the examples in it. It does.
Yeah, I will take the examples too. Let us see. As to illustration A, a shopkeeper has in his till marked rupees soon after it was stolen, and cannot count for the possession specifically, but continually receiving rupees in the course of his business. Now, this is the example of a person who is in stolen property के बारे में illustration दिया गया है. This is a shopkeeper can take up the plea that here this money is in my possession, so he can dislodge the illustration. Then has to be a person of a highest character is tried for causing a man's death by an act of negligence in ranging certain machinery. Be a person of equally good character who also took part in the arrangement, describes precisely what was done and admits and explains common carelessness of A and himself. Now here, if this man is explaining, both the persons are guilty of the offences, that the court will take into consideration, draw presumption that it is an accomplice. He is the person who is giving evidence. It may be unworthy of him, but it must be need to be compensated. But in this case, a person of a good character means the court does not need to take into consideration the evidence of the under 156, 157. Corroboration is not required. See, as per this illustration, somebody of a good character, he admits it here, the court may presume that he is a gentleman. Like today, for example, MJ Akbar versus Ramani's case, his defamation case has been dismissed. You know that here. Ramani has laid evidence that the MJ Akbar does not have reputation. You read today's order or not? Delhi court judgment.
No, sir, but he managed to he managed to prove that, sir.
No, he could not. The case is dismissed because he took up the plea that my reputation is injured in society. She has defamed me. I am a very respectable journalist. But she has totally brought him down by examining several girl journalists who said that this man has outraged our modesty. The court said he cannot claim himself to be a man of credit. He doesn't have reputation in the market. The case means Ramani stand to succeed here. The illustration to section 499, 500 stands corrected. The truth is a defense to affirmation. So the court believed her statement here in that matter. So please read the today's judgment by opening your whatever the legal ads and all, you'll come to know that. This is today's.
Then what happens to MJ Akbar? Is finished.
He is finished. What that I do not know. Will be finished or again come back. He might go and appeal or revision against the order. We do not know. But this is the trial court. She has succeeded. She successfully fought before the court and lodged evidence that he doesn't have reputation. So the court believed her evidence. Court believed her evidence. Yes, that is whatever he has done to her is true. A truth is a defense. So here in this illustration, the court is believing the evidence of this gentleman, though he was also involved in the commission of the offense. He is an accomplice. That means corroboration is not required. Illustration B. Now illustration B. A crime is committed by several persons A, B, C. Three of the criminals captured on the spot and kept apart from each other. Each gives an account of the crime implication. D, and accounts corroborate each other in such a manner as to render previous concert highly improbable. So in this case, something which is improbable and they were kept separately, that means they were not tried jointly, that means corroboration is required. This illustration falls also under the provisions of section 30. Section 30 हमने कल पढ़ा आपको सामने, isn't it? The consideration of a confession affecting the making of a person and the other person. So this will come under the provisions of illustration B. So when they are not tried together, the confession is not binding. Yes, next see that here. As to illustration B, then ho gaya hai. Then next, as to illustration C, a drawer of a bill of exchange was a man of business. B, the acceptor was a young and ignorant person, completely and under A's influence. Under A's influence. So the court is not bound to draw inferences against him, because under the Indian Contract Act, you know that a contract is bad if it is vitiated for undue influence. आप समझे ना यहाँ पे?
Yes, sir.
When there is undue influence, so there is no parity between the gentleman, a big businessman, and ignorant person. So the court will not draw inference against the uneducated man. The court will be more merciful towards him. When parties are standing in a parallel position, they are in a competing position, that the court will draw inferences. Okay, next. As to illustration D, it is proved that a river ran into certain course of 5 years ago, but it is known that there have been floods such that in time it might change its course. So Ganges river coming from Himalayas, going in direction, it causes floods in certain areas. So the court may draw presumption that here, that certain people who were swimming, who had gone there for fishing, maybe taking bath, are not traceable. So this is an account of the Ganges, the river taking, causing flood or maybe situation flowing from direction. The court may draw a presumption that this is on account of this happening. Yes. Then as to illustration E, a judicial act, the regularity of which is in question, was performed under exceptional circumstances. A judicial act, regularity of which in question was performed under exceptional circumstances. So in A.R. Antule versus Naik case, you can see that here the Supreme Court laid down the Roznama maintained by the judge, the judicial orders, whatever is mentioned by the learned judge is to be accepted, and not the parties what they orally come and say about the order. It is ultimately, it is expected that a judicial officer will not do wrong recording. Unless the order is erroneous, you can challenge before the superior court. Certain things which the court may record today, for example, the court may record that today the matter was placed for hearing, the accused did not turn up. The court may issue a bailable warrant, non-bailable warrant, some kind of orders may be passed. The accused cannot turn up and say that I had come, the Roznama is wrong. See, unless the accused person takes up the plea that here I was there. But when the name was called out, why did you not mention your name? Why did you not raise? Your lawyer was not there. So you cannot blame the judge for recording a Roznama. So the Roznama maintained by the judge, a judicial act which has been performed, will prevail rather than the oral statement of the accused person or the litigant. Yeah, next. As to illustration F, the question is whether letter was received. It is shown to have been posted, but the usual course of the post was interrupted by disturbances. So when you dispatch a letter from the post office, GPO Mumbai, it presumes that it has reached the destination of the addressee in Calcutta, Thane, Delhi. But on account of disturbances, flood, on account of COVID-19 situation, it has not reached in time. Normally, a registered letter reaches in about 7 days' time from Bombay to Delhi. It has not reached in 15 days' time due to unavoidable reason, due to reason beyond the control, due to pandemic, a reason. So the court may draw presumption in that regard. Okay. Then as to illustration F, illustration G, sorry. A man refuses to produce a document which would bear on a contract of a small importance on which he is sued, but which might also injure the feeling and reputation of his family. So if you call upon the defendant to produce a particular document, isn't it? Both in the CRPC and in the CPC, there are provisions contained for protection of a document. So you may examine a witness, even you may also ask the person certain person to produce document without examining him. That provision you will find under Order 16, Rule 16, CPC. Similarly, under Section 91 and 92 CRPC, you also provision is the magistrate or a judge can summon the witness to get document. And the document which is sought for and you do not produce it, the court may draw presumption that you are deliberately not producing because that document will go against you, against your case. So that is the reason. Now, maybe the court may feel that maybe in a defamation case, your reputation of a family will be harmed. For example, the court may ask him to produce certain letters written ensued between the parties. Certain virginal letters are if they are not produced, both the parties have a right to exchange letters, documents, all this. If they are not produced, if you call upon your adversary to produce the income tax returns, call upon him to produce the board meeting resolution. You may be a director of a company. Some resolution is passed terminating you from the post of a vice president, whatever may be. You call upon the company secretary and the directors to produce the resolution and they don't produce it. Then if they don't produce it, the court will draw a presumption that you are deliberately, the company deliberately not producing because that will go against them. Okay. The court can draw under the Evidence Act, it is known as drawing of adverse inferences. क्या बोलते हैं? Adverse inferences which will go against the person. Please note that. So there is also a provision under the CRPC. You will know that a witness who does not produce the document, when he is summoned to produce it, he can be sentenced to jail for 7 days. मालूम है आपको CRPC पढ़े भूल गए? Section 349, I think it is, if I am not mistaken.
The witness?
If a witness who has been told to bring document, if he doesn't produce it, what are the consequences in CRPC?
So, but where will the witness get the documents?
Suppose a witness may be having documents.
Okay.
Yeah, a witness is under Section 91 CRPC. 91 का खोलिए आप, मालूम पड़ेगा अभी. Related to evidence, Section 91, 92 खोलिए.
7 days simple imprisonment, sir.
7 days imprisonment under Section 349. So that provision relating to document is 91. 91 खोलिए आप, सेक्शन 91 CRPC 91-92. Someone to produce document. Got it? Are you getting it?
There is network issue.
Section 91 CRPC.
So that the police officer or the court may, under circumstances, issue an order or summons for the production of any document or thing if such
Yes.
production is necessary.
Yes. 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 That is 91. And telegrams and letters 92. The consequences of non-protection are given under 349. 349 खोलिए CRPC का.
If any witness or person called to produce a document or thing before a criminal court refuses to answer a question as are put to him to produce any document or thing in his possession or power which the court requires him to produce and does not a reasonable opportunity has been given to him to do so, offer any reasonable excuse for such refusal, such court may, for reasons to be recorded in writing, sentence him to simple imprisonment or by warrant under the hand of the presiding magistrate or judge, commit him to the custody of an officer of the court for any term not exceeding 7 days.
7 days. और CPC के अंदर ऑर्डर 16 में क्या है? The property can be attached. He can also be, क्या नाम है? The consequences are little lesser serious here. That's different. So here, under the Evidence Act, the court will draw adverse inferences. So this will go against a person who doesn't bring the document. Okay.
So what happens if these documents will incriminate the person bringing it?
If it incriminates, also you have to bring the document under the Evidence Act. That is there is no bar, no. That is section. I just gave you the evidence. Section 132. Witness not excused from answering the ground that will criminate. Section 132 is the answer. Evidence Act, you are bound to bring it here if it is relevant to the issue in the matter. You cannot suppress it. That is why section 91, 92 is given. And 91, 92 अगर नहीं follow करें, the magistrate can issue search warrant under section 93. Isn't it? The magistrate can 93, 94 के अंदर your place can become unsealed. These are consequences of it.
So then what is the way out, sir? How would you avoid this?
There is no question of avoiding. If somebody has committed a crime, he has to produce the document. Okay. Otherwise, the court will draw adverse inference against him. Huh? That is the only reason. Otherwise, you may take up the plea that the documents have been destroyed. The court will draw adverse inference against you. You are in possession. You are known to be in possession of this document. Why you are not producing it? If somebody takes up the plea that the agreement which you have drafted, A and B, A says that my property has been taken fraudulently by the B by executing fraudulent document and without paying me consideration, and the original is lying with him. If the court is calling upon him to produce the original document, he has to produce it. अगर नहीं produce करेगा, he cannot say that I become the owner. When he has filed a suit for declaration on the strength of the document, he is bound to produce the document. If he doesn't produce the document, that he will not be in a position to substantiate it, case number one, and the court will draw adverse inference. Deliberately, he is not producing the document because that will go against him. Now, Mr. B is entitled to lead oral evidence challenging the document under section 91 of the Evidence Act. Normally, when there is a written document in the nature of a primary evidence or secondary evidence, parties are not permitted to lead oral evidence. But when there is a fraud is committed, that there are circumstances which the court can permit you to lead oral evidence, those sections you will see section 91, 91 and 92. 92, the exclusion of evidence of oral agreement. See, when the terms of any contract or grant or disposition or any matter required by law to be reduced in the form of document. So, agreement of sale says that here it must be written document. Under the MOFA Act, under the FEMA Act, whatever may, there must be a written document. Under Transfer of Property Act Section 54, agreement of sale must be in document. Has been proved according to the last section, no evidence of a oral agreement shall be admitted. So, when there is the original document, stamped document, you cannot lead oral evidence as between the parties and the instrument or the representatives in the interest for the purpose of contradicting, varying, addition from the see the proviso. And any fact may be proved which would invalidate any document. So, if the defendant takes up the plea that the document is invalid, bogus, my consideration was not paid, see, invalid document, or which is entitled to any person, or the decree or order relating to such a fraud, intimidation, illegality, want of due execution, want of capacity, willful consideration in law, this will permit you to lead oral evidence. Then item number 2, proviso mein existence of a separate oral agreement. You may take up the plea that here the plaintiff had told me that here this agreement was not to be acted upon. There will be a oral arrangement. Number C, existence of a separate oral agreement. Existence of a distinct separate agreement. So, under the Indian Contract Act, you have learned doctrine of novatio under section 42 of the Indian Contract Act. After the execution of a agreement, parties enter into another agreement, maybe oral or written. A novatio, you can lead oral evidence. So, when a document, you are establishing a fraud under section 17 of the Indian Evidence Act, you learn that here, fraud vicious transaction. A suit with regard to fraud, evidence should be filed within a period from the date when evidence was discovered, fraud was discovered. Yeah? Section 17 में पढ़े आपने Evidence Act के अंदर, isn't it? So here, when you take up the plea that here the agreement was sham, colorable, bogus, and not to be acted upon, and when the court has called upon you to produce it before the court, and you don't produce it because knowing you fully know that either that document is not sufficiently stamped. If the document is not sufficiently stamped, it is hid by section 49 of the Registration Act. Number 1, so your ownership goes, and you are deliberately not producing because you are not paid him consideration. It is hid by section 25 of the Indian Contract Act. When fraud is proved, then hit by section 23 of the Indian Contract Act, opposed to public policy, against any, it is injurious to any person. So the court may draw all these presumptions. Under 114, this is a very widely connected section. It is not just Evidence Act. It is connected to the provisions of Limitation Act, connected to a Transfer of Property Act, connected to your Specific Relief Act, connected to your many MOFA Act. ये सब चीजें आएंगे इसके अंदर. No, please note that here. Evidence Act you cannot read, as I told you, in isolation. It must be given a harmonious interpretation, reading along with the other substantive laws as well as the procedural laws. So the adverse inference will be drawn by the court against the person who doesn't produce. Apart from the fact that there are penal consequences flowing under the provisions of section right now 91, 92, if you do not follow the provisions of 349, you can go to jail. वो apart है. ये civil cases के अंदर the court, that is itself, you lose your case. The plaintiff will not be able to succeed. Okay, is that clear now? Then as to illustration H, a man refuses to answer a question which he is not compelled by law to answer, but he answers to it might cause loss to him in the matter unconnected with the matter relation to which is asked. So this is with relate to that. I told you that here he cannot excuse if a man refuses to answer a question which he is not compelled by law to answer. If he doesn't answer the question, the court may draw advertency. If he answers this, he may think that it may criminate. In the case of a criminal, he can't be arrested. At the most, there will be a prosecution against him under 340. Yes. Then illustration last May, a bond is in possession of an obligator, but the circumstances of the case are such he may have stolen it. Suppose I took loan from you, ₹1,00,000 under a promissory note. You are my good friend. You invite me for lunch or dinner one day. मुझे मालूम हो गया कि आपने अलमारी के अंदर आपकी प्रॉमिसरी नोट रखे, मैं चोरी कर लिया. Isn't it? So you can lead evidence that here he has not returned back my 1,00,000 which he has paid, but on the contrary, he has stolen back the document. So adverse inference should be drawn against him and not me in the matter. So the court cannot draw an inference that the promissory note has come back to the person who took the loan, that is me, and the court should not draw inference that the loan is discharged. You may lead evidence that the document has been stolen. That immediately I lodge a FIR to the police station. You may prove that. You may also show that the amount of loan was given to him by check. I have also shown it in my entries, books of account. You may examine your books of account. I reflected in my income tax entries. So under the provisions of section, when you see 34, please open your section 34. One minute, I'm sorry. Yeah, section 34, देख लीजिए, entries of books of account including maintained by electronic form when relevant. So you have a right to show before the court that here, at the time when I gave the loan on promissory note, I made an entry. This entry is not removed by me. There is a FIR against him. He has not paid back the amount to me. So they cannot be an inference against me. In fact, there should be an inference against him in that matter. So though section 34 permits you to lead evidence with regard to entries, it required to be, again, the law says that it is required to be substantiated. Okay? Yeah, that will complete the 114. Anybody wants to have, then I will take the next sections which speaks of may presume. What are the other sections I had given you on your net? Just see that.
Sir, quick question, sir.
Pujye.
Sir, people will give accusations and counter accusations so that the court doesn't draw adverse inference. So where will the court draw the line and how will they come out of the impasse?
See, it depends on matter to matter and the evidence is recorded. Because when you sit in the court of law, when you record evidence in a particular matter, you come to know what kind of questions are put by your lawyer in the cross-examination and examination in chief. At the relevant time, the court is watching the demeanor of the witnesses and as well as the counsel asking questions. During the course of the questioning, when relevant documents come into picture, normally when documents are to be adduced, you give the other side a notice, isn't it? There's a provision in the CPC as well as in the Evidence Act, notice to give protection, isn't it? Protection notice to be given. That I'll point out to you the relevant section again. CPC के अंदर पढ़े आप section order 11 और rule 13 पढ़े आपने. Then Evidence Act में भी उसमें section relevant section है. देखिए notice का section 63 पढ़िए 163, 162, 160 protection of document. 162 protection of document, 163 giving evidence and documents, 164 using evidence document protection which may be refused. So when you can refuse is given here. When a party refuses to produce document which he has noticed to produce, he cannot afterward use the document as evidence without the consent of the other party or the other. Now under 164, he will not be allowed to tender later on without the consent. Now under 114, the court will draw adverse inference. Isn't it? Now under 165, the judge has infinite powers, untrampled powers to ask any question or asking for protection of any document, relevant or irrelevant. Nobody can question the judge. So please remember these sections very well with regard to protection of document. Understood?
Yes, sir. Thank you,
Yes.
sir.
Yes. Now come the next other provision. Now with this section 4 makes you travel to learn almost every section of the Indian Evidence Act, because you have to read the Evidence Act this way only. You just cannot read from serially 1, 2, 3, 4, 5, 6, 163. So we have to connect it. Please make a mental note of it. And when you are giving in the examination writing also, and also when you are in the practice, this is how it is done. Now the next sections which I mentioned to you are what are the other sections I given to you on the net? Just can you just briefly get to me? Section 77, 78, 79, 80, barabari? You want me to explain the sections, or will you go through? Yeah, let me know the answer. You all will go to the sections, or you want me to take you through?
Sir, nothing like your guidance, sir.
Okay, I will go through. Yes, yeah. Now, the other sections, yeah. Just give me one. I'll just drink some water with your permission. My throat is getting, yeah.
Please, sir. Please.
Yeah.
So what is this that they are asking, even in for small matters, they're asking counsels to be present in court, but they are talking about lockdown on the other hand. Is that right, sir?
Lockdown
And they're not even giving permission to counsels to do video conferencing for all matters. They're saying the court is open, so please come to the court.
only extremely urgent matters you are entitled to appear and argue before the court, and otherwise other matters courts are little liberal, and wherever the possible, if the counsel is a senior citizen, you cannot compel him to come and appear before the court. And they are giving, you have to make an application for video conferencing. The High Court is permitting. High Court is permitting, the Supreme Court is permitting, and the lower courts are little reluctant because they are overburdened, and they expect you to come and argue before the magistrate and the Court of Sessions and the small causes court, city civil court. There are no adequate arrangement for video conferencing. I must tell you that. How much time? How much time we have spent so far now? 45 minutes, 1 hour.
So we are at 7:07, so about an hour, sir.
Can we take 5 minutes break?
Yes, sir.
I also need some break because I had a very heavy day. Okay.
Yes, sir. So any cases?
Yeah, Gita.
Yes,
any cases that you would like to share once we come back?
Yeah,
So should we log out and log back in, or stay
No, stay logged in. Stay logged in.
No. You can. This lecture is finished now. Second lecture I will take after some time. After 10 minutes. Okay.
Okay, sir.
This lecture stands terminated now. Now the next lecture we'll take it up after 10 minutes. Okay.
Okay, sir. Thank you, sir.
Yeah. Okay. Bye. Thanks.